Well. Doing that as the agenda here, right? Oh, I didn't.
Can you go off the screen till I print them?
Yeah. Okay. There we go. Can you, do the, all right, so I'll please decide that because my eyes are. There we go. Oh, that beautiful thing.
The simple agenda tonight.
Very simple. Okay, so we have my greenhouse. Is she supposed to be keeping track of this? Are we waiting for Marina to come back?
Excuse me?
Are we waiting for Marina to come back?
She's taking the notes and everything, so.
Yeah. Well, believe she's already recorded. Yeah, she's already recorded.
Oh, okay. Okay, so our call to order, we have 1, 2, 3, 4, 5 members, my greenhouse, Fred Oliver.
Actually, we have 4 members and we'll seat an alternate when the regular meeting starts.
Oh, okay,
We'll seat Joan
okay,
at that time.
okay. So Bill, Kathleen. And so this is our continuation of the application of Christine Gomez. Seeking a variance for the lot on Mussola Road. So presentation by the applicant.
Just for the record, Attorney George representing the applicant. I have the applicant homeowners here with me, or property owners, I should say. I didn't really prepare an additional presentation. I know that we were continued primarily because we wanted to have a full complement of 5 members to vote on the application. There was also a question of me just putting down a bit of a summary that I presented at the last meeting so you could digest it further. And then I'm really more prepared just to answer questions at this time. I certainly don't have any new legal arguments that hasn't already been expressed.
Well, I know, so Joan will be seated as an alternate, so we have 5 this time.
Yes,
I don't know. I know Chair being chair. I've been the chair for so long.
yeah,
But she might have questions that.
absolutely. And I presume that you've had an opportunity to either review the recordings or review the minutes. And
I looked at the whole recording.
okay, okay. Thank you, we appreciate that.
And you feel that you are qualified to participate or vote in this matter? Say,
If they seat me, I am.
yes, she feels that she's been updated by watching the videos.
you watched the video, you've reviewed the file, right? And so you feel prepared to participate or vote.
Yes, I
Thank you. That's what I would be.
Thank you. So yes, so if there's any questions, again, if you want to refer to the summary of the argument and my legal basis for it that I had submitted, that really walks you through what I had presented at the last time. We're starting with the premise that, well, I guess what I should say is that the primary, first and foremost question that we presented before you is that we would like your confirmation this is a legal non-conforming lot. And as such, then the basis for our requested variance can be the Adelson principle, which is a reduction in nonconformities. We would be reducing via this lot line adjustment the nonconformities having to do with lot width and lot size. There will be no other nonconformities, no new nonconformities created, just those 2 will be reduced and made more compliant. I've set forth my arguments as to why we maintain that it should be found a legal non-conforming lot. As you know, we're in a bit of a quandary. We can't definitively prove it one way or the other. We can't definitively disprove it either because the town's own records only go back to 1956, despite having purported to adopt zoning in 1950. We've done the best with any information at our disposal, and we can either I think it's for you to now, based on the arguments I've made, make a determination. Have we given you enough information in the record to make a reasoned conclusion that yes, we will deem this to be a non-conforming lot and therefore evaluate the variance request based on Adelson or not? And even without the direct evidence of what the regulations said in 1954, when this lot was created, we've given you some inferences, right? The best we can get based on what the regulations said in 1956, based on some minutes of a zoning hearing that repealed and modified changes to regulations, all of that I think is also a basis for you concluding that you could infer that the prior regulations either didn't set a minimum lot area or width, or set one that's different than what's in the 1956 ones. Otherwise, why would they have changed it in 1956? And therefore lead to the conclusion that it was likely a compliant lot when it was created. So I wish I could be clear. I mean, I wish it could be cleaner is what I want to say. I wish it could be cleaner. I wish I could give you a definitive answer. I did research who is the keeper of the town's records, and according to the state library, they're to be maintained in perpetuity with the town. So the state librarian wouldn't have a copy of these. This is something that should be housed in the town clerk's office. Again, there's just nothing there prior to the 56 regs. So based on all of that, is there anything specifically you want to ask?
And I don't know if it's John, so I have a kind of a lawyer question, I guess. I feel like you're, so now we're gonna put a house on a lot that never had a house before, but and your argument is based on the old lot, but you've changed the lot, so I feel like I don't know, does the reduction in nonconformity really apply? Because now you have a brand new lot that's nonconforming.
Well, we have a lot that was non-conforming. We have a lot from 1954, a piece of land.
Okay.
Whether you call it a building lot or not, it's a parcel of land that's been in existence, standalone without any adjoining property, in common ownership since 1954. And in 1954, that piece was created and it's been vacant ever since. So that parcel exists. What we want to do now is modify the lot lines of that parcel and enlarge it to become more compliant with the regulations. Whether a building goes on there or not, it would be more compliant with the regulations, because the regulations require a 40,000 square foot and 200-foot minimum lot width. So we will be making it more compliant, still not compliant, but more compliant than what's presently existing with the lot. And the house will fully comply with all setback requirements and all lot coverage requirements. So it's really solely a matter of the lot width and area, and whether there's a house there or not, the principle doesn't change, that we're making that parcel more compliant with the zoning regulations.
I just feel like it's not that parcel anymore, it's a new parcel.
Well, with the variances, it would be a modified parcel. But we're not creating it out of nowhere. I mean, it does exist right now, and it has since 1954, based on the chain of title.
I mean, I'm not.
That plot has always existed without structure.
Correct. But there are lots of pieces of land that have not yet been built on.
Sure.
Right, right, and I guess I want to not lose sight of the fact that if built upon, the structure itself can conform with all applicable regulations. The structure can, the house, okay?
I just was wondering if there's like past precedent of similar type case, and I apologize that I haven't had time to get here in a couple weeks, to research it for myself. But perhaps examples of, because there's many non-conforming lots apparently around the lake, is my understanding. Where similarly, a vacant lot was purchased with the intention of placing a structure and has zoning issued variance previously. And then a second follow-up question to that would be, has zoning also granted variance in the past? Is there past precedent for zoning to grant variance with the stipulation that they make an adjacent lot less conforming or make it non-conforming? That specifically in regards to the situation regarding the septic plan. Because foreseeable future, if one lot was sold, I just.
Well-
Want to know if there is past precedent.
I can't talk to whether there's past precedent, but I do want to caution you, we are not making the existing house lot non-compliant in any way with zoning. Zoning is fully satisfied, it will still meet all bulk area requirements, size, setbacks, frontage. That lot will remain compliant, so I know it'll be a little unusual because the septic, it will have someone else's septic via easement on the front part of it, but there's no non-compliance issue. If we were making it non-compliant, it would be an issue. Then the eight principle really would not come into play because you can only use that to make properties more compliant, not create new non-compliances. So that's kind of an important differential there. So I'd just like to point that out. And with regard to the septic being on the existing house lot and kind of off property, kind of a little bit of both. Having septics within an easement on adjacent property is something the health department has allowed, will allow. And it's really no different than having an easement for drainage onto your neighbor's property. I mean, oftentimes you see a roof drain, a curtain drain, or something being drained from one property to another. Here we're, putting our leach fields and draining that onto another property, but we can memorialize that via permanent easements that will run with the land, be apparent to anybody who would buy the property and spell out the rights and obligations in that document.
So on that note, one of the thoughts that I had, is kind of going pontificate a little bit here. I went to a site where they had a bamboo forest on this.
Oh,
piece of
what?
property,
Bamboo?
Bamboo forest.
Okay.
And it's green year round in Rhode Island. And I thought, wow, this would be really cool.
Bamboo's invasive.
That's my point. It's very invasive. So I was told never plant bamboo on your lot because it's invasive, it goes into your septic system, blah, 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 blah. But then that made me think too, so this piece of property right here that the septic system would be on, the owners of this lot, and I know it's you now, but in the future, they would never be able to build something in that area, put trees or plants in that area because the septic system's there. And I also thought, and again, I'm pontificating a little bit, I put a trench on the side of my garden once to put underground lines out to my pool house. And the guy that dug the line said, your septic system's right there, I said, yeah, he says, well, you got all these trees you wanna plant and you have to dig this. And I said, yeah, he goes, you don't wanna do that. So I guess my point is, how far of an area in addition to this, would you have to say to people, you can't plant trees in this area? If they didn't know, because those trees could grow roots into that septic system. And now the person that owns the new house could say, I have damaged my septic system and I'm gonna sue you for damages because your trees that you planted on your lot, even though they're outside the septic system area, had roots go in there. And now that's one of my thoughts I had in my head.
Yeah, I don't think that we really have to worry about putting any restrictions beyond the septic easement area. Number one, it's a steeply sloped area, correct?
Yeah, I was just thinking, if you were to go to see the property, then did you go to see the property and then the main?
Just from the road, look
Right,
up.
and so our main house and the yard and the whole area that we use, we have never in the
35 years.
35 years used that down there in 35 years. Because the area and the yard is big and the grass and everything is lovely up there, like you wouldn't even go down there for that, so.
The slope's really kind of separated.
Yeah,
the
the
house
slope
may be
really
less
separated,
visible.
if you were to see it, but I appreciate you really giving thought to this, I appreciate that.
So within the actual septic easement, you can see where the primary would be, and you can see where the perk tests are. The primary is pretty close to the property line in the interior part of the septic easement. So I don't think, even if someone planted, which again, based on topography and slopes, I think it's unlikely anyone would plant. But even if someone planted outside of that easement area, I don't expect that we would have,
I'm sorry, here, wait.
yes.
Go ahead, Ray.
I was just
You
pointing,
just pointed out the exact location of the primary field versus
Closer
the,
to the easement area.
yeah. So the easement area is actually quite a bit larger
Right.
than the,
I think we've given
than the septic
sufficient
system.
surrounding area to protect the structures
Structure.
within there. So for reasons of the fact that I think it's impractical that anyone will plant anything down there or do anything with that area, other than the septic system. I don't think we're gonna have any interference. Another thing I'll just note, and I know variances can't have anything to do with the ownership and who owns the property, but I will just note from a practical standpoint, my client does expect her son to build a house there. It will be a family-owned property, at least in the foreseeable future when it's first built. So with that, relationship in mind, I don't really expect any incompatibility by having the easement on the rear house's property.
can I ask about the easement? I'm assuming the easement is going to give give parcel B
Mhm.
the right to pass and repass and maintain,
Yes,
including
repair, replace, yep.
including mowing and repairs and all that good stuff.
It'll be very broad. I mean, I'm happy to review the language with the town attorney to make sure it covers everything, but I envision that it will be the right to pass, repass, construct, maintain, repair, replace as necessary, a septic system and all appurtenances that may be necessary, and to do routine maintenance. It will also allow the owner of the house lot, the existing house lot, to use it for a purpose that's not inconsistent and interfere with any of the septic. So title still remains in the house property and they have some limited rights to use it, but again, it's so kind of remote in a way from the house that it's really impractical for use anyway. So I don't envision them retaining any real activity and exerting any control over that land. They really just own the underlying fee.
Right, but somebody's gonna have to maintain it to prevent trees from
Yes.
reestablishing themselves.
And that will be an obligation on the parcel B owner to make sure that they protect their septic system.
And if by chance that was poorly maintained and caused pollution on someone else's property, that would be.
Well, whoever,
responsibility of-
it's the septic owner's responsibility, so they would be responsible for any damage there.
Right.
I mean, you can almost kind of wipe out the easement in your mind and almost make it seem like that land is really primarily for the benefit of and under the control of parcel B, but legal title of the underlying fee is still owned by the house, so that the house lot can stay compliant. That's I think I mentioned to you, that was the important drive behind that. It often only works if we're not creating new non-compliances. We wanted to make sure that the existing house lot that my clients live in stays compliant with all zoning requirements.
So can we just review, how much of a non-conformity are we asking in terms of square footage of the lot and the different dimensions?
Sure, so right now, I put that in my memo, right now we are making the lot, which is presently 18,703 square feet.
Right.
We're increasing it to 25,118 square feet. And we're increasing the lot width from 50 feet to 88.7 feet.
And so 25,118 is the square footage, and the minimum called for by the zoning regulations
Is 60,000.
60,000. Okay, so that's still a big, okay, 60. And as, well, keep going. And as far as the dimensions, so
Mhm.
how far off are we on the various dimensions?
Oh, no, we're not at all.
Okay.
As you can see from the proposed location of the house lot, we will be front, side and rear yard setbacks.
Yeah, I see the setbacks,
Oh.
but in terms of the dimensions,
Sorry.
the frontage, for example, is that?
Well, you don't
it's
have a
just square
frontage
footage?
requirement, you only have a lot width, which is the 200,
We actually do have a frontage requirement as of January 15th, 2026.
okay, but not as of the date we submitted the application, but what is it now?
200 feet.
Okay, so lot width and frontage are two
They
hundred.
changed it, they
Okay.
changed it.
So 200 feet is what's required, 50 feet is what's existing, 88.7 is what we're proposing to increase it to.
And setback from the road is
50 feet from the center lane,
Yeah.
and they're
53.
yeah.
What's the square footage of the proposed house?
of the house.
Well, we don't have a final building plan for the house. I mean, that could change, but it will have to comply with all setbacks. What we're showing here, just because it's still a small lot, so it can't really accommodate the McMansion of any sort, is oh gosh, I don't have,
4 bedroom.
yeah, but what, can you tell the rough dimensions of it? I don't have
30 by 40 are the rough.
30 by 40.
Yeah, 30 by
It's about
40.
1,200 square
Two
feet.
stories?
Yeah.
30 by
It
40.
could be, I mean, again, there's no final building plan for it. So,
Right,
I'm sorry?
yeah,
so somewhere in the neighborhood of 2,000 square feet, it sounds like it would be kind of a ballpark. Because if it's 30 by 40, that's 1,200.
1,200, yeah. So if it has a second story, then it could be up to,
Yeah, then we'll have it.
yeah.
Okay.
Mr. Chairman, for the record, Mark Riggs, I have a question on that as a follow-up. Typically, if your plan shows a 30 by 40, that's like the envelope within which the building will occur.
Mhm,
So
yeah.
it won't, if this variance is approved, it can't go bigger than that.
Oh, no.
No, we don't expect to go bigger. I mean, I guess the only thing I would say though, Mark, is, Attorney Brand, sorry. Is that as long as we still don't need setback variances, I would think there's a little flexibility with that. I mean, as long as we're out of the front, side and rear, I mean, that, because the size of the house doesn't really change the variance that's being granted for this is really more of an for the lot area and width. This is really more academic because my clients can live with,
Okay,
working within
yeah,
that
I mean, I'm
footprint,
thinking-
but I'm
thinking
not
in an
sure.
Thinking in an case, you know.
Yeah.
That variance case.
Okay.
Where, you know, sort of what you see is what you get.
Okay,
And I think that it is relevant for the board.
okay,
I mean, if the house is gonna be twice as big,
No.
that might affect their.
Yeah.
Their, if it's roughly this, if it's a little different shape.
Yeah.
I don't think it's a big deal.
Yeah.
But if the board knew that the house is gonna be much bigger, that is a factor. I'm not saying that it would make a difference, but it's a factor they would consider.
yeah.
So my understanding is this, you'll be within that envelope.
Or smaller.
We can live with that, right?
Yeah, oh, absolutely, actually, I was thinking
Yeah.
smaller,
Mhm.
they were thinking smaller,
Okay.
but.
Yes, that if you want to tie the approval specifically to this footprint, we don't object to that.
No.
Yeah.
And I might have asked this question before, so if I did, I apologize. So the area for the septic system, could that be sold along with that, or would that make the original lot too small?
It would make the original house lot too small, and not too small, really, it would affect the lot width. So we could probably still make the lot area work, but they wouldn't have the requisite 200 feet of lot width, and so it would become non-compliant there. So that's really the
That's why that, okay.
touch point, yeah. I mean, that would be the easy solution, right? Then we.
Yeah, the solution to
Right,
add that.
then I just say, we'll just add it to this piece, but my biggest concern all along was, let's folks protect what we have and not make our existing lot non-compliant.
No, fine.
Right.
So that's really my, playing lawyer and being real particular about complying with the law.
So, yeah, so to make the new lot compliant, you'd have to bring it from roughly 25,000 square feet up to 60,000. So
Oh, yeah.
there's just no.
There's no-
There's not enough land to do that. Okay.
Yeah, and I mean, and this gets into the whole, is this in accordance with the comprehensive plan and consistent with the neighborhood? I talked about this at the last meeting and I also put it in my summary. I mean, there are a lot of undersized lots in this area. We pointed out at least 4 within,
The street.
700 or 700,
If you drive around the lake, you'll see.
yeah,
as many
750
as you look
feet or
for.
so that are
And that's
smaller.
what, I walk the lake loop all the time. So
Yeah.
I walk the lake loop and you start seeing the houses, you get to know everybody, get to know the houses,
But
it's
there's
small.
no new ones, are there?
Right, no, agreed,
I mean, the
agreed.
ones you cited, the newest one's 35 years old.
Well, no,
And
the ones
down
on our
to
street.
The one that was built in 1930, 1953, 1930. So,
Prior to
Well,
prior to the zoning records like 1954.
I just wanna touch on that, cause I know, we're building a new house, and I know that's causing you a little concern, but I want you to recognize that people can even do that without a variance on an undersized lot. The zoning regulations have some protections for non-conforming lots. And it says that as long as the lot was of record by 1950, which is the only issue, and the only reason we're really here is because we can't get those darn zoning records from 1950, we only go back to 1956. But as long as the lot was owned a separate as of 1950, and as long as you can comply with health code and don't need any setback variances, then they can get a zoning permit to build a house on an undersized lot. So the only reason I'm not fitting, my clients aren't fitting squarely within that, and the reason they're coming here is because of this issue with the lack of regulations. So I have to somehow get you to agree that we're not gonna hold tight to that 1950 date because there's nothing there to tell whether or not we were existing or what was existing at the time. So that's really the only reason my client can't fit into here, and I advise them to come before this board to get a variance because of that 6-year gap.
But if Wayne had an application to build a house
Yes,
on a lot that was less than 60,000 square feet, wouldn't you reject it because it didn't?
I would say you need to get a variance, yes.
Yeah, that you would have to get a variance.
but you don't need to, because
That's what I'm
it's
saying.
illegal if it's a non-conforming lot. Under section 4.12 of your zoning regs, if it's a non-conforming lot and it was non-conforming as of 1950, when the regs, if it was legally existing prior to regs, and there's no adjacent property owned, just like here, and you comply with health code, and you don't need any setback variances, then you can get,
Oh,
a zoning
if you can fit it, yes.
if you can, without setback, but if it's undersized with regard to area or width, you don't need a variance.
Okay.
So those are where we're undersized.
That's also dependent on the 1950
Mhm.
timeline. So I think that's where my question, I don't know if I'm asking it appropriately, but in regards to past precedent, are there cases this side of 1950 where variance has been granted, or is it reasonable to infer from the other existing non-conforming lots that have structures, is it reasonable to infer from that at the time, those were what was recognized as legal building lots, and this was never intended to be built upon?
For the record, Mark Brains, first of all, precedent for ZBA variances is mostly non-applicable, because every situation is so unique.
Okay, so
Whether the houses that you're observing, some of them, they may have predated zoning, they may have gotten variances, but it really isn't determinative for your decision. I mean, the question before you is whether on these facts and these circumstances, you feel that a variance is in order by virtue of the Adelson case, as Attorney Reiser has said, that by the reduction in nonconformity. So the fact that there are other houses on non-conforming lots, maybe they were variances, maybe they predated zoning. It doesn't really cut one way or the other for you.
I think
Case by case basis.
I think then I want to make sure that I'm not looking at it from the, so we were told that we need to approach it from the realm of the fact that these zoning regulations were not on the record prior to a certain date. So we were told that we needed to look at how it applies in regards to the time frame that the zoning regulations, that was how we were instructed, or so to say that like we shouldn't be looking at past precedent.
I mean, you can consider it, but it's not determinative. I mean, people will always say to you, people will always come to you and say, well, you gave a variance to that guy, so you have to give me one to me. No, That's what I mean by precedent not being binding. The fact that you had a certain topography, a certain location, a certain number of square feet, you thought a variance was in order in that case, doesn't mean that in anything that's roughly comparable, you have to give a variance, and vice versa. The fact that you denied one in one case doesn't mean that you can't approve it in one that arguably is similar, because no two pieces of property are ever exactly the same. The only way you're bound by precedent would be in a case where you're interpreting what the regulation means. And that would happen if you were getting a CEO appeal, wouldn't arise in a variance. If you were getting an appeal from the decision of the zoning enforcement officer, then it might be relevant as to how those words were read in the past. But for purposes of tonight, you don't need to worry about that. And Attorney Reiser, do you?
I agree with that, 100. I think variances are all case by case. People might say otherwise, but I don't think you should worry about setting precedent or abiding by precedent. I think you need to look at this based on the facts and circumstances, and they're fairly unique. I mean, we've got a situation here. How many properties can you say go back to their chain of title in 1954, 4 years after adoption of zoning regulations? Yet we can't read the zoning regulations. I mean, this is the first time I've ever had to make this argument. So it's a fairly unique situation all around. I guess I'm imploring on you to not hold it against the property owner and the applicant that the town doesn't have the records we need to fall squarely within the zoning right that says we can, build even if we're undersized, and prove to you that we were without a doubt legally non-conforming when the lot was created in 54. Chess.
So because I did my due diligence, I actually had because I didn't know, I had a title search done, which I wasn't actually required to do. I went what I felt like was doing my due diligence, going above and beyond. And I had an attorney do the closing. The title search went all the way back and it's a clean title. They went all the way back as far as they could. That for me was doing my due diligence. If the title search had come back and brought something to my attention, I would have had to make a choice at that point. But I did my due diligence, and there was the town didn't keep records for as long as we're now talking about this situation. So I'm not sure what else I could have done.
So I guess I just don't understand now, like this minimum lot area square footage. I mean, this rule of 60 was in place before you bought the lot. I guess, I mean, I could see where, like, if it was the original owner and they bought it when it was considered buildable, but now it's not real, I don't know.
What you're saying is she bought a lot that she knew was non-conforming and decided, I'm gonna try and make it.
But the non-conformity runs with the land, right? That if it's a legal non-conformity, it's a vested right in the property. It doesn't matter if the property changes hands and someone buys it knowing it's legally non-conforming. They still have the same rights as the previous owner.
But there's no.
If it's legally non-conforming, that's a vested property right that doesn't go away despite transfer of ownership.
It is legally non-conforming.
Right.
So what they're saying is like around the lake, they have a lot of really not.
I know that, and the houses are there, and if something is there for more than 3 years, it's grandfather kind of.
That's- Don't use that. Don't go there. That's a totally different.
So my mind's going where, I mean, I guess it doesn't apply, it's just,
Right. It does.
I.
And by the way, Attorney Rice is correct. If a predecessor in title had a hardship or had an Adelson argument, then the current owner has a hardship or Adelson argument. So what you're referring to is often called the buyer with knowledge rule. The buyer with knowledge rule only applies where the prior owner had no hardship either. All right, so it's if the first owner could have gotten a variance under the Adelson rule, then the current owner can get a variance under the Adelson rule.
And forgive my naivete, and you all have far more knowledge about this. You have to understand, as a layperson, I walked around Lake, I saw, there's a lot. I contacted the owner. And it is my naivete, which is why I hired an attorney and did a title search. So that was my due diligence, because you see all of this all the time. You sit here every, and I appreciate your service to our town. I love this town. I just didn't, as a lay person, you look and say, oh, there's a house, there's a house, there's a house. Here's a lot for sale, I can buy this lot. So I appreciate you're coming from a different knowledge base than I am, and literally, I thought I was going above and beyond with a title search. I was kind of a little bit proud of myself. As a retired teacher, I like to do my homework. And, I was proud of myself that I did that, and yet I guess it still had, it still couldn't go as far as it needed to because of the town record, so that, but I hear what you were saying.
Madam Chairman, for the record, again, I'm Greg, just to keep this balanced. A title search typically wouldn't disclose zoning history or zoning rights, okay? It's looking at title. So no title search is gonna tell you whether you do or don't need variance.
Oh, no, it wasn't about the variance, it was simply about the records going back as far as we would need them to go back. That's one.
So the title search went back, confirmed good title for 40 years. The title search typically when an attorney gets a title search, they will review it and see, okay, what's happened to the property during that period of time. I would say a good attorney should identify if a property has been divided over that period of time. They would want to be investigating whether that division was properly done. If it required subdivision, if it didn't require subdivision, then you'd have to go another step further to make sure that the parcels conformed. It doesn't appear that that was done, and there would have been no way, again, even if it had been done, for them to verify. Because the records, the zoning records don't go back far enough. The only way we can definitively verify is if we knew what the regulations said in 1954, when the lot was first created, and we just have a big blank there. So we can either assume it was legally created due to the lack of records, or we can infer based on what the 1956 regulations said, that the 1954 unavailable records were complied with. And were different than 1956. Again, I really do think they had to have been different than the 1956 ones, because why else would they have made a change to minimum lot size and width? It had to have been something different. You don't make a change if it's the exact same. But I don't know what it was, so I can't say definitively it complied, but I think there's enough reason and inference there for you to reach that conclusion and a court to uphold it if you so choose. The courts will give you a lot of discretion in doing the best you can under the circumstances with the information you have, and as long as there's a basis in the record for logically reaching a conclusion, I believe the courts will uphold that.
I have a question for the attorneys here. As it's been stated, this lot seems to have been created in 1954 by basically, but by
Yeah.
I don't know what the word is, what the words are, by it not being included in transfer of land. Does that actually create a lot, or was the lot actually created when the first deed that I can come across is from 1980 that described this 50-foot lot in a transfer?
No, it would be created when it was severed off from any adjoining parcels. I mean, it first shown as a portion of a
Right.
lot in 1927, but it was only a portion, and then it was conveyed along
It
with some
actually
other
moved from
parcels.
lot to lot.
I'm sorry?
It moved from lot 53
Right.
to lot 54, and then it was left out.
Right, so it was, it was part of lot 54 and 5, right? It was kind of those three and the southerly piece of lot 53. Those were all kind of grouped together. Then the owner conveyed away 54 and 55, which created in essence a leftover piece, a lot, a parcel. maybe not a building lot, but that remains to be seen, but a parcel of land. And so in 1954 is the first time that we see it, as a standalone piece and then conveyed separately from that. And just because there wasn't a deed that specifically described it as a standalone in 1953, it was effectively created because the balance of the land around it was conveyed off. So she retained, the owner at that time retained just this 100-foot by 50-foot.
So it was never, if I'm understanding what you're saying, Wayne, it was never actually created as a non-conforming lot. It was just a piece of land that was left off of two other pieces of land that were conveyed to other people. And it just created this vacant lot. It was never actually, I don't know how you say, created as a non-conforming lot. It was never set up as a legal non-conforming lot, someone to buy
I
something.
don't think you want to use the word legal non-conforming lot,
Okay.
a lot, a parcel.
In
Was it ever
1927,
created as a parcel of land? Was it just a locked off section parcel of land that was left there?
in 1927, this wasn't shown as a separate parcel, it was shown as part of lot 53, which is kind of, I mean, with the line, it's a little unusual, kind of looks like 1, 2, 3. It almost looks like 4 of the surrounding lots all grouped together, but like the 1927 map shows it as this parcel as part of lot 53. And then in
You said 53.
1927, it was part of lot 53. And then it conveyed over the course of time with lots 54 and 55, which were similar in length and width to this piece. They were 50 by 100. Or 370, I'm sorry, 50 by 370, which is very similar to this one, but for some reason on the 1927 map, there was a compilation of like 3 or 4 of them that were all kind of grouped together as lot 53. So lot 54 and 55 were 50 by 370, and then those conveyed along with the southerly 50 feet of lot 53, which is this remaining piece. Then after that, 54 and 55 were subsequently carved off and sold to someone else, and the owner Shirley Riley retained that 50-foot.
I'm bringing to the board, copies of the, 1927 DAG map that was, amended in 1934. I don't know if it help you there.
Yeah.
So. Which you're talking about lot 53. This is lot 53. It comprises all of these.
All lines,
All of these is lot 53.
from here to here,
Here.
that's all like from here.
Lot 54 and 55 were sold separately. Somehow in 1953, 54, this 50-foot piece, this is piece that is,
In question right there.
that's parcel B.
That parcel B, and this here was sold to somebody else.
Right, this was actually sold to the people, to someone who bought 54 and 55. It was included in 54 and 55. And then 54 and 55 were subsequently sold, leaving that piece. Leaving that. Was that correct?
Yeah, in 1927.
It's over 100 years ago.
I understand.
Well, it's actually 1934 is when they drew that.
1934. But those were all like individual
Those were all
lots.
50 by 100-foot lots, all over the place, all the way.
Oh.
Because this was a man-made break.
Yeah, the lake was real estate. real estate.
So these similar lots then, you said 54 and 55 are sold together.
They're sold
So
together.
The property becomes much more valuable with this water
56,
nearby.
57, 58, the other ones that look very similar, are those individual lots that are built on?
They were actually sold together too. I don't think they're relevant to this discussion.
Well, what's relevant to me is that were other homes or other lots designed at that time to be sold as lots, as 50 foot by whatever, were all these designed, because it looked like that, the way they're all designed, all the way down the street. There's like 10 lots that are all 50 foot wide. Is that the way the land was intended to be
So
sold?
we infer what was in the mind of the Andover Lake.
You know what I'm saying? Why was someone create all these 50 foot wide?
Attorney Brandt, can I chime in? Because I think he said that that holds no bearing, right? That's what I gather from you.
I think, and also, it was common for these, you have to remember, no one understands today what a difference air conditioning made. Right? During this period of time, you had these lake communities being built all over New England.
Right.
So people built a cottage, a summer cottage on a body of water to escape the heat of summer in the city, right? And people bought 2 or 3 of them. You might put a little tiny cottage on one of them. Some, as you can see, some people bought several, built a bigger house, and over time they were winterized. But I think what I want to drop back to is something that Wayne was saying a few minutes ago, that this parcel was not, quote, separately described in a deed as of 1954, right? And your regulation, the regulation that Attorney Reiser was referencing is that the deed, it's legally non-conforming, it was separately described, but it wasn't separately described. But that, in my opinion, is why they're here for variance, all right? That the fact that it wasn't separate, that's why they would have an argument that they don't need a variance if it had been separately described in 1954. It wasn't, right? But it does exist as a separate parcel, separately described or otherwise. And I, since we are low on time, I do think that you have, to echo something that Attorney Reiser said, I do think that you have discretion to grant or deny, and I think you do have a little discretion. And if in terms of, is it in harmony with the purpose and spirit of the regulations? Is the reduction in nonconformity sufficient to balance the creation of another house? All those sorts of factors that you've been kicking around here are all relevant. And so I think you have discretion whichever way you go.
And also does limiting it to the footprint, so it's not an oversized
Yeah.
house, also that balances in, if you feel that's appropriate, we can make that a specific, tie the approval, if you so fit, to the specific footprint, so it's not a McMansion out there and disproportionate with what else we're seeing.
And I probably shouldn't advocate for the proponent, but there are 2 letters on record of support from 66 Pasula, which is up the hill, block 54 and 55, and across the street, I believe.
Right, the house is closest to
Where this house will be.
where this house will be. They're very supportive. And the house, there's our house.
And 66 Pasula was at the public hearing last.
Yes.
Yeah, their only concern was the blasting, and that doesn't need to be done because there's no ledge there. And once that was satisfied, they were all set.
Yeah, but they didn't speak in opposition to.
No.
I agree with Attorney Brandt, it's really, it's the board's.
There's another meeting at 7 o'clock, so we'll be done at 7 o'clock. Hopefully,
Or hopefully,
so yeah, if there's any other, Brett, if you wanna
okay.
ask us any other questions from this board, and if we want to.
So do we have any more questions? Are we done? Anybody have any more? So we can wrap up this part of our meeting?
I don't have anything else to offer. The only thing I would say is if you're still, on the fence and you're feeling rushed now, because I know we have another meeting coming in. Even if you close the hearing, I mean, we would love a decision, but if you don't feel there's time to deliberate tonight, then, you can always deliberate at the next meeting.
Well,
Again, I would really wanna make sure that all 5 of you are here though at the next meeting.
that's the
That was
applicant,
all,
that's the applicant's decision though, right?
What's it? No, it's up to you. You can do that whenever you,
Oh, I thought,
whether I want you to or to vote tonight or not, you have the discretion of closing and then you don't have to make a decision for a period of time.
If you close the public hearing, you have up to 65 days to make a decision. So it could be your next regular meeting and you can find.
Yeah.
okay. So do we need to make a motion to do this, or we just close there?
We're going to close the meeting.
Okay, so do motion.
Public hearing.
We're done. I think we just say.
Okay, so close the public hearing. And now we do a call to order for our special meeting. Time at 6:50. 6:50, call to order at 6:50.
Need to, we need to see.
Okay, so we need to make a motion to seat an alternate.
I make a motion to seat Joan Ross as our alternate.
I'll second the motion.
Any discussion?
Any discussion about
The
that?
only discussion I have is, the only reason I'm not going to use you is because she was here. I got it, yeah, a lot longer here, a lot more than you.
You'll get your chance.
Either other alternate. You're so a little late, so anyways.
Okay. So therefore, all in favor?
Aye.
Aye. Anybody against or abstaining? So Joe is hereby seated. Any new business? This is our new
Is the
business.
seating somebody needs?
I'm sorry,
I don't think
The
so.
vote was, because
to seat Joan as an alternate.
Joan, but she abstained, correct? From seating herself?
She can vote.
She can vote? She can vote, okay. So 5-0.
Even if she didn't, there's.
I abstained from that vote, I thought.
You didn't have to.
Okay. All right, so
Yeah, I
that,
vote for myself, come on.
yeah, why not? Somebody has to. All right, so deliberation and action on the application of Christine Gomez seeking a variance. Applicant seeking relief from sections 11.2 of the Andover zoning regulations intended to reduce the nonconformities of a currently vacant parcel on Basala Road, MDL, I don't know if there's no, 32 to 48, 53 CB. The applicant's intention is to adjust the boundary line between the vacant property owned by the applicant and 52 Basala Road, owned by the applicant. The proposed additional land added to the vacant parcel and an easement on 52 Basala to locate a septic system is intended to support the construction of a single-family dwelling on the vacant parcel. So,
Now you would basically entertain a motion.
okay.
Or you're deliberating. and then-
We would deliberate further, but
Okay, so do we have a motion? Anybody wish?
Mr. Kasichak has prepared for you a motion for approval and a motion for denial. And I would note for you that the motion for approval he already drafted for you has compliance to the plan submitted, so you don't need a special condition about the house shape or anything like that.
Do we have that? Or, sorry, thanks.
This is provided the applicant to where he was.
Oh, yeah.
Did I hear it?
No. Not where you would answer that is.
I think you're.
I'm sorry.
Limit to that square
Didn't know I was supposed to do that.
You know, it may not be that shape, but it's 40.
I'm learning it.
It's all right.
Not so that.
Yeah.
Yeah. Very forced, but just the first time you did is very nice.
We went over
Thank you.
this all the last time.
Yes.
The first time, so I'm all set.
Okay. So there were two motions prepared, one to approve, and one to deny.
There's actually a third motion there.
There's still a motion.
Third motion to continue the deliberation.
Oh, yeah, that's true, it's true. Mike?
We already,
I read the motion, I read the proposed motions. Being a newer member, I first not make the first,
Okay.
you know, if that's okay, I don't.
I'll make a motion to approve and we can discuss it, and then we can either vote either way, it's how it would go. So I'll make the motion to approve, move the application 2515 ZBA Christine Combs, the approved act code provides for a reduction in non-committees associated with the parcel
NBLU 32/48/53 CB, volume 147, page 77. Specifically, the board varies section 11.2 Andover Lake District lot area from 60,000 square feet to 25,000 square feet. 25,118 square feet, and the frontage from 200 to 87.71 feet as depicted on the boundary reconfiguration plan prepared by Rob Holstrom, Land Surveying LLC, dated December 4th, 2025. With the conditions also stated here. So, that makes it open for discussion.
We'll do it second.
Or do we have a second? Do we have a
Second, is anybody want to second Phil's motion?
I will second.
All right, so
Mike?
Greenhouse has seconded, so that makes it open for discussion.
Yes. Any further discussion?
I'm just not sure I'm comfortable. I know there's a million little non-conforming lots and a million little houses on them. That mean we have to keep propagating that? I don't know, and the septic thing, 2 septics on one building lot is a little weird to me, but I, you know, I don't have a lot of experience, so I'm saying I'm not real comfortable.
But this isn't gonna be a little house, it's just not gonna be that. But they're planning.
Right.
There's gonna be 2 septics on one building lot.
I don't-
And then a house on a lot that doesn't meet our current building requirements.
I don't think that that's what we're
Well, it does.
here to,
52 Pasula meets the
Yeah.
requirements for the lot.
yeah.
It does now, and it will after.
And I think that the attorneys, kind of made it a little bit more clear to me that we're not really here to deliberate that aspect of it. It's more so, how the parcel was conveyed at the time. And I think it would be reasonable to infer that, you know, first of all, you're looking at, this was the original lot size right here. And they're asking for a variance to have it be more conforming. So at the time, I think it's reasonable to infer that those were the lot
Don't
sizes.
confuse 1934 with 1950.
No, that's true too. Yeah, that was, again, if you look into that plan there, 1934 is like 1954.
Right. But we're also to understand that there aren't zoning regulations that existed.
Unfortunately, to my chagrin, I tore this building apart looking for them.
5 minutes, please. 5 minutes, be done.
We're just finishing, but not really.
5 minutes, thank you.
So there likely were, but we just don't know what they.
I have probed everywhere I can think
Right.
of. I've asked every person I can think of, and I don't think there's anybody alive from that period of time.
Right.
So,
That's an interesting one.
So what's hanging me up is just the smallness of the lot, even with the additional piece of lot 53. Or the additional piece of the conforming lot, that we're still talking a small lot, and I agree with June that. I don't know that we should be perpetuating small lots.
I agree with that also, and
They're not seated, so, okay, we should move to question unless there's any further discussion.
Okay.
4 minutes to.
Okay. So,
So what happens if there needs to be a continuation
It
then?
doesn't need to be a continuation, there's a motion, we vote on it right now, that's the case.
If you wanna keep talking about it,
We can keep talking about it if you want to go to another third meeting, or we can call the question and take vote.
so we've moved and we've seconded, so let's show.
somebody can call the question if they want. They wish.
I would like to move the question.
Okay,
Jeremy, would you like to move the question?
I don't know what that means.
You want to vote? You want to vote? You want to move to another meeting?
those are our choices. Either we'll keep it rolling.
Let's
or-
do it. Okay, vote. Do you want to vote or move to another
Do we
meeting?
feel comfortable voting? Michael, do you
I'm
feel-
comfortable voting.
Are you okay for voting tonight?
Yes.
Okay. Yes. Call the vote.
I'll vote, so all in favor of Bill's motion to approve of this proposal? Say aye. Aye. Yeah, that gives us three, and so all against?
So it's two.
What?
So,
Wait a minute, you voted twice.
no,
No, she
She
did.
voted once, she voted to approve, we made, you had 2 votes against. That means motion did not carry, because you got 4 to the motion, so you're right. So,
Yeah.
sorry about that, folks.
No. Is that?
So we have to, so our next thing is, next regular meeting, February 18th. Mr. Thomas Bass.
I will not be here.
Okay, do we have anything
You
on-
can show up, I won't be here.
Do we have anything for that, Wayne, or?
Not yet, we don't like,
Okay.
okay, but you let us know.
So if we hear from Wayne, motion to adjourn. Bill,
I'll make
motion,
the motion.
Bill, motion to adjourn at 7 o'clock on the button. Second, all in favor? Meeting is adjourned. So keep coming, Jeff, we'll give you Dave. Did you get the messages? Did you get the?
For your time today. Thank you.
This was at.
Yes.
It was at 6. I didn't.